not in any way trying to stop the defendant being able to conduct cross-examination. I guess I disagree a little bit. I think the court does have the ultimate discretion over the allowance of cross-examination in compliance with the rules of evidence to make sure people stay within the bounds. What the state has concerns about was any attempt by defense to misconstrue the content or attempt to create a situation where the defense then argues, well, we have to put prosecutor Wood on the stand, and especially without conducting any kind of a hearing in advance. The state does appreciate the comments made by the defense that there is no intent to call Mr. Wood as a witness. I guess it still makes the state a little bit nervous because, as the courts pointed out, we've litigated this issue multiple times. The state also recognizes that sometimes trial strategies change. And if at any point that does, the state still doesn't want to end up in that position. Because I guess while defense says we're just going to question her and maybe show her the still creates a concern for the state that then later the defense is going to say, given now prosecutor Would. So while I appreciate the representations made by defense counsel, I think that is still the concern surrounding these messages. The state does not disagree that so long as the defense counsel sets the proper foundation, he would be able to absolutely use these messages if he were trying to introduce them. I guess I should be clear on the proper foundation. I don't disagree. I don't think the state disagrees at all that cross-examination can include asking about meeting with the state, meeting with investigators. That would all be fair game. The concern would be an attempt to misconstrue the statements. And that was why the state was asking the court to potentially review them in camera to make any ruling regarding those messages or conduct a taint hearing if necessary. I think the court was very clear with defense counsel that if there was going to be an attempt to call prosecutor Wood, a taint hearing would be required. I guess the state is not still completely assured that this would not still result in that attempt to essentially circumvent the court's prior orders. So that's the concern with the state.
Okay, thank you, Ms. Blake. Mr. Pryor, Ms. Blake was still talking, so I'm sure that didn't come on the record. What did you say?
If I could respond briefly, Judge.
You may.
Thank you, Your Honor. Judge, I've already assured the court, and I'm not going to violate the court's order about Mr. Wood. And frankly, the state can say if certain things happen, but the reality is this court can make rulings on relevance issues as it relates to certain things. But when we're talking about credibility, Idaho Code 9201 allows me the leeway to go forward and impeach a witness or ask a witness about communications with a prosecuting attorney. And it's perfectly permissible. Just because Ms. Gibb may say something different than what a text message is, I can show her, refresh her recollection, and that's as far as it goes. And I understand that. I understand the limitation that's put on impeachment and refreshing someone's recollection. It doesn't open the door, and the state's using this opportunity to say, well, Judge, in the past, you've stopped Mr. Pryor from having him talk about his many conversations with the other witnesses. But in this situation, it's a different story. Ms. Gibb is the witness in this case. Her testimony is crucial to the state even trying to prove their case. And the reality is that I'm allowed to talk about communications with Mr. Wood and Miss Wood, or Mr. Wood and Miss Gibb, to the tune of 340 text messages over a little more than a 6-month period. So I am allowed to go into that, and I'm going to go into content if that content. So the suggestion is that there should be a taint hearing. They are completely off base. And what they're trying to do is they're trying to, strap a motion that has previously been ruled on and say, Judge, oh, there still may be some threat here. We really better go through this long process and have you evaluate things. And I'm going to object if that's where we're going. I'm allowed to go into the credibility, bias, and motives behind any witness. And I'm allowed to question them about anything that may go to bias, motive, and in that regard. So I appreciate the state conceding finally that I can use this information on cross-examination, judge as a representation on cross-examination and maybe direct examination when Ms. Gibb is subpoenaed. That's where I intend to go. And again, I will reiterate, I do not intend to call Mr. Wood, nor do I plan some scheme. Sounds a little paranoid to me, but that's fine. But again, I'm going to follow this court's order. But 9201 allows me to go into the credibility of the witnesses, and I don't feel like I need permission to do that.
All right, the matter's been argued. I am ready to make a ruling on it. So I am gonna put the ruling on the record. I'll just have an order entered that will say for the reasons stated, because I don't expect either side to draft out in an express order the analysis I'll go through here. So as it relates, first of all, I'll indicate that 9201, of course, reiterates the provenance of the jury, that they're the ones that determine credibility of witnesses ultimately, and that clearly states that. The matter of evidence is always, though, for the court to determine what evidence comes in or does not come based on actions or during trial, and the court always has to, on which is whether or not evidence is relevant, and 403, which is potentially, even though there is some relevance, two oh one, as the defense has argued it anyway, or the two are mutually compatible, in that if it will determine relevance. one. I can simply determine if I think it's appropriate that the jurors shouldn't be hearing about these communications if it does nothing to help them assess the credibility of the witness. So ultimately, it has to be an assessment of the witness's credibility. I don't think a taint hearing is necessary or required at this point. If during the course of that testimony, we start going right into this, and it looks like there may well be an issue if that were to come up with credibility relating to Exhibit 113. I do agree that that should be done either in camera or at least outside of the presence of the jurors to avoid any unnecessary confusion the jurors may have sorting out what that would mean if it doesn't go directly to the credibility of that testimony. As it relates to Mr. Wood potentially being called as a witness, there's been a representation to the court today. That's not what the defense intends to do. This court's previously ruled that that was not going to happen. I still don't intend to have that happen. I can't say that could never happen because anything is possible. Particularly, it seems in this case. I'm not going to predict what may or may not come out, but I don't see much of a path forward, given how strict the analysis is to permit that. So absent some really surprising or extenuating development, Mr. Woods not going to be called as a witness and would not be permitted to under the controlling law. And finally, on that invited error doctrine, again, as I mentioned, to the extent this would be sort of invited error, it would law objection to if we start getting in an issue that could potentially bring a motion for a mistrial. So ruling time then is on those matters, Mr. Wood's not going to be called as a witness. The Exhibit 113 is not excluded, but the court will watch for any relevance objections if the state believes it's not relevant. And that's the ruling on the motion.
Thank you, Judge.
All right, Ms. Blake, do you have any questions on that ruling?
I do not, Your Honor. Thank you.
All right. And counsel, one final thing, as I mentioned, if it becomes necessary for either an in-camera review or just argument outside the presence of the jury, please try and flag that, or I will sua sponte before bell gets rung in front of the jurors. They shouldn't be hearing. So that will conclude then the ruling on the motion. At this time, if we are ready, we'll have the jurors brought back in to continue testimony.
Yes, sir.
I don't know if you guys can hear me right. It would have to be technical, but I don't know how good the signal is going to be. I'll try and drop the board, but
All right, thank you, Mr. Bailiff. Please be seated. All right, we are on the record on case CR 22-21-1623. The jury has returned, is all properly seated. Thank you for your patience while we went through a couple of matters outside your presence today. It would be the intent of the court then to go straight through till our time to end today at 3:30. Everybody on the jury okay with that plan? Okay, if anybody for whatever reason does need some break, just notify the bailiff. Otherwise, we'll intend to go through the afternoon. Ms. Blake, I believe you're still on direct examination with Detective Duncan, is that correct?
Yes, Your Honor, that is correct.
I'd like to call away. All right, Detective Duncan has returned to the stand. Let me just inquire. I'm not singling you out, by the way. I do this with every witness when I remember, but over this break, did you discuss your testimony with anyone else or anybody else's testimony? Okay, thank you for confirming that. Ms. Blake, if you'd like to inquire, I'll remind the witness you're still under oath and you may question.
Thank you. Detective Duncan, before the break, we had just heard two calls that were linked to the same mortuary call. Do you recall those?
I do, yes.
And you recovered those as part of the investigation?
Yes,
And I believe you indicated the FBI had actually requested you collect those calls.
correct.
And prior to today, had you heard those?
I have, yes.
Have you heard Chad Daybell's voice?
I have.
Were you able to recognize the voice on that call?
Yes, I was.
And who was that?
Chad Daybell.
And during the call, did you hear him use any other name than Chad Daybell?
I heard him use a different spelling of the last name, yes.
And in that call, do you recall him saying where he was hoping to send the remains to once they were cremated?
I do.
And where was that?
Louisiana,
Do you know where Charles Vallow's place of birth was?
Louisiana.
Do you know if he still had family living there?
Yes, he did.
Did you also hear Chad give a location for himself where he was currently located in that call?
He indicated that he was in Iowa.
Through your investigation, did you ever find anything indicating Chad was in Iowa?
Did not.
And we've talked about that in your investigation, you looked at the iCloud accounts for Lori.
Yes,
Do you recall locating a copy of a patriarchal blessing?
there is an audio recording of a patriarchal blessing on Lori's iCloud account.
Did you listen to that blessing at some point?
I did.
And do you know who was giving the blessing?
Chad Daybell,
Do you know who he was giving the blessing to?
Alex Cox.
Are you familiar with what faith the patriarchal blessings are attached to?
I am
And what faith is that?
with the Church of Jesus Christ of Latter-day Saints.
And are you familiar with whether or not Chad Daybell within the church would have been authorized to give an actual patriarchal blessing?
Sustained. And Ms. Pryor, your microphone next time, please.
Detective, as part of the investigation, did the LDS faith come up?
Yes,
Did you review some things in relation to that faith?
I did.
And do you have some basic knowledge regarding the LDS church?
Yes, I do.
Do you know what a patriarchal blessing is?
I do.
Do you know who's authorized to give those within the LDS faith?
The stake president is authorized to give those.
Do you know what if Chad held the calling of a stake president at the time the blessing was given?
My understanding, he did not.
So he would not have been authorized within the LDS faith to give that blessing.
Correct. I think it actually would correct myself. Like it's a stake patriarch that gives that blessing, not president, but a patriarch.
So it's a specific calling someone has within the faith to be able to give those blessings to another person.
Yes, it is.
And Chad did not hold that calling.
My understanding, he did not.
And Your Honor, the iCloud accounts have been admitted into evidence. The state has what's been marked as State's Exhibit 50, which is the reference to recording, where those iCloud accounts are already in evidence by stipulation. The state would move for the admission of State's Exhibit 50.
No objection, Judge.
Okay, exhibit 50 is entered, and counsel, again, to be clear with those accounts, et cetera, as each individual item comes in into evidence, as you just did, Ms. Blake, continue to please reference those specifically so the record remains clear.
Thank you, Your Honor. The state would ask for permission to publish State's Exhibit 50.
You may publish.
Chad Daybell. It is November 24th, 2019, it's Sunday afternoon, 5:15 p.m. We're going to give Alex Lamar Cox a patriarchal blessing.
Alexander Lamar.
Alexander Lamar Cox. On this special day, I lay my hands upon your head to give you a patriarchal blessing. As part of the member of the Church of the Firstborn, that you have earned the privilege to be a member of. I do so by the power of the Melchizedek priesthood which I hold, and in the name of Jesus Christ, our Savior, who has authorized this blessing. It is grateful that you're receiving it as you move forward in your life. You are a member of the house of Israel, of the 12 tribes, and you are a descendant of Joseph through the tribe of Ephraim, which grants you many blessings, particularly of spreading the gospel in these latter days and protecting and preserving those who seek to learn the truth. And that has been your mission on this earth, and it will now expand into ways that we will discuss further in the blessing. I want to begin by opening it to your sister and you helped her in numerous probations as a defender of us. connections you've always had with him. And through adulthood, you have refined yourself. So you'll begin into your this existence. You'll be a power servant. I bless you with knowledge that you've heard the out upon you. I bless you with the knowledge that through marriage, you'll be united with a partner who will match your powers and complement your strengths. You'll be known throughout the world for your good-heartedness, your willingness to save souls all over the world through portals, and you will begin to gather the souls that come unto Christ. I see you in New Jerusalem, but more importantly, I see you as a messenger of the Lord. Surrounding New Jerusalem will be many small communities where people will come who aren't quite ready to enter those heavenly gates, those terrestrial gates. And one of your missions will be to go among the people and testify as a prophet that they can make it. You'll share your own experiences of overcoming adversity. And through your example, they will rise up. You will give tremendous blessings to them, raise their vibrations, and be like a brother to many of these fathers who may have had doubts, but through your strength, they will look to you as a hero, and you'll bring entire families that have been sanctified to the gates of New Jerusalem, and they will be allowed in on your word. Oh, me, just one of the many wonderful experiences you'll have. I see you doing that often, but then based on assignments, you might go further into the world. Always serving, always a missionary. And with your companion, you'll communicate with Mother Earth herself. You'll know where to be before natural disasters happen, that you can be on location to protect key leaders, church leaders. Okay. A lot of